The next bill on the calendar for the day is Senate File 86. The clerk will report the bill.
Senate File number 86, number 7 on the calendar for the day, an act relating to data practices.
I recognize the author from Blue Earth, Representative Cornish, who will explain the bill.
Mr. Speaker, I think I have an amendment at the desk to put in the House language.
The clerk will report the amendment.
Cornish moves to amend Senate File number 86, the third engrossment, delete everything after the enacting clause and insert the following language of House File number 222, the second engrossment, and the amendment is coded DEA 222.
Call upon the author of the amendment from Blue Earth, Representative Cornish.
Mr. Speaker and members, what we just did was institute the House language into the Senate file there. The Senate came over with the bill that had body cams in it. We haven't heard that, and the House doesn't have it, so we put the House language as it passed the Civil Law Committee and the Public Safety Committee. Members, this is the LPR bill, the license plate reader, the automatic license plate reader bill. Sometimes when members get up in front of you, they'll claim to have a bipartisan bill when sometimes it's only like 1 or 2 votes. This actually is a bipartisan bill, and I'll tell you why. Representative Scott and I have worked on this from different directions when we started out, and we negotiated on this with law enforcement, with the privacy advocacy groups, and finally, after days of negotiation, a couple informational meetings, and meetings in Representative Scott's office with all the groups involved, we came to a resolution and offered the bill up in civil law, where it passed with maybe 1 dissenting vote, and then I think 15 to 1 in the public safety. And there was some amendments tried and failed, and the bill kept intact the way it was. And I'll give you a quick summary. The bill started out scary to some advocacy groups and others because of the surveillance terms and other things and automatic license plate readers. And for that reason, the language we worked on made a lot of changes. It started out at 180 days, you know, and now it's down. It died, I think, in conference last year, year before, at 90. Now it's down to 30 days in the House. And I'll just run through a few of the changes here. Oh, heck, I know them from memory. What we have here is now we have to report whether a stationary device is being used in its location. We have yearly audits by an independent groups. We have a classification of data that the subject will be able to get a hold of the data. We have a 30-day retention and then to dump the information. And so if some of you don't know how license plate readers work, it's a device that's fixed to your car and automatically reads your license plate in the area surrounding it, admittedly. And then it goes into a database if the bill passes. Another few of the protections we made for citizens was if it goes into this database can't be shared with other law enforcement agencies only under certain conditions. So if Hennepin County goes to Ramsey County and said, I'd like this license plate number checked in its location, they can only do that if they have reasonable suspicion a crime has been committed and there's an active case investigation with a number assigned to it. It can't be just on a whim. Also, we don't allow the statewide database in this. Any statewide, there would be separate databases for the law enforcement groups, and we can't share it with the feds if they request the information automatically. So we put in a lot of protections with the audits, the checks. We have public logs that are accessible. And I think we've done everything to take care of the rumors around LPR. And you wouldn't believe, like I discussed in caucus earlier, all the things that you can envision this being used for and the scary stories in relation to this and that and the other thing, and keeping track of people from where they went to the sandwich shop to the sporting goods show and get a diagram of where everybody lived. I just don't think that that's happening, and with the protections that we're putting on it, I think we'll be good to go. Also, in relation to the retention of data, it's all over the board for the nation. There's, as far as I could tell, there weren't any states with 0 retention. There's states with 3-day, 7-day, 3 years, and in perpetuity. So it's all over And so I'm comfortable with the bill we've got now, taking it into conference committee. The Senate is very much like this, with a lot of protections, and go into it and come to a resolve. But I think we've got a bill here. And as with the gun bills earlier, you know, one thing I tried to do is not to shove anything down anybody's throat before they're ready. We took a long time with this. We got input. I think even the DFL side will admit everybody had access and input into the idea, and most of all you folks on that side voted for it in committee anyway. So I would not like to take any amendments today. I would like to bring this in this shape into conference committee, and with that I urge your support. Thank you.
Members, we are on adoption of the delete all amendment to put the bill in substitute the House language in. Seeing no further discussion, all those in favor, please signify by saying aye. Opposed, say nay. The motion prevails. The amendment is adopted. There's an amendment at the desk. The clerk will report the amendment.
Lesh moves to amend Senate File Number 86 as amended, and the amendment is coded A15-0726.
Call upon the author of the amendment from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. I withdraw the amendment.
Representative Lesh withdraws the amendment. There's another amendment at the desk. The clerk will report the amendment.
Lesh moves to amend Senate File Number 86 as amended. The amendment is coded A15-0727.
Call upon the author, the member from Ramsey, Representative Lesh.
Mr. Speaker, I withdraw this amendment.
Representative Lesh withdraws the A15-0727 amendment. There's another amendment at the desk. The clerk will report this amendment. Representative Lesh, this is the A15-0728 amendment. Do you wish to offer that?
I wish to withdraw that one as well, Mr. Speaker.
So we will not offer that.
I can save you
0729.
some time, Mr. Speaker, saying I'm only offering the 0730.
There's an amendment at the desk. The clerk will report the amendment.
Lesh moves to amend Senate File Number 86 as amended, and the amendment is coded A15-0730.
Call upon the author of the amendment from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. Members, first I want to commend Representative Cornish and also Representative Scott for the compromise that they reached on this bill, including the First Amendment that just went on, Representative Cornish's First Amendment. I wish it hadn't taken as long as it did, but I will say that the amendment offered by law enforcement in the March 13th Civil Law Committee, the DE1 amendment, was a marked change from the previous positions that they had held. Those are mostly reflected in the bill that Senator Latz sent over, Senate File 86. But unfortunately, they did not do the compromise work that Representative Cornish and Representative Scott had done in order to get this bill in a position that I think was palatable for most of the folks around here. I will add this, that I don't like it. I don't like the compromise for this reason, that it still retains data on innocent people. And if you believe that people in this country are innocent until proven guilty, by your ascension to this compromise, you are admitting that government can hold personal information about your whereabouts at any given time of day without your consent, on the suspicion that maybe you might do something guilty in the next 30 days, something that would be wrong in the next 30 days. That said, I do think they worked really hard because folks were coming from very different perspectives on this bill, privacy advocates, as well as law enforcement. And I have to tell you, I am very impressed with the lobbying power of law enforcement around here. They got a lot of clout. You saw it a little bit on medical marijuana last year, and many of us who have served on public safety for quite a years have seen it a lot. But they brought their full force to bear in order to ensure that the principles reflected in the Senate bill are going to be the result. So why am I offering this amendment then? The reason is because I think the compromise forged by Representative Cornish and Representative Scott, and the substantial work they did with that, is a good one. It's a good compromise. As I stated, I'm not fully satisfied, but they actually did the work to arrive at it. I do not see that reflected in the result that came out of the Senate. They went straight up to 90 days. Now, yes, the position of the chiefs of police 2 years ago was 180. But 2 years ago, they were already saying they'd do 90. So there was no movement from that point, from the number of days on the part of law enforcement in the Senate. In the House, there was movement. So I do not think that the House should have done the work on a compromise bill on which many people have very differing positions and go into conference committee and negotiate against a bill for which there has been no compromise. To give you some background, why is this important? Because license plate readers, to a lot of people, even on this floor, it's kind of hazy what they do. I'm going to start off with this. The Minnesota Data Practices Act in Chapter 13 presumes that all information collected and held on you by government is public. This is an incredibly important feature of American liberty, that if government is going to do something to you, you can track down and find out why, find out the background. Our committee meetings are public. The Minnesota Data Open Meeting Law says that city council meetings are public. If we collect driver's license records on you that are incorrect, you can review them and determine whether they're inaccurate because they're public. If you have convictions on your record that are incorrect, you can review them because they're public. This is basic to American democracy. With that in mind, in 2012, the Minneapolis Star-Tribune was made aware that the Minneapolis Police Department was using technology called Automatic License Plate Reader, ALPR. So they made a Minnesota Data Practices Act request and demanded all the records and images for a year. This was in June of 2012. Now, Minneapolis at that time had 8 mobile cameras split between police and traffic vehicles and 2 stationary ones that captured 4.9 million license plates in that capture. 4.9 million license plate images. Less than 1%, in fact 0.8% of those 4.9 million images were the quote-unquote bad guys. Okay, now, not necessarily, because this just captured folks where the image suggested that they could be a bad guy. However many convictions came out of those images, we'll never know, because all it says is whether someone was driving, whether the registered owner of the vehicle that plate was attached to had a warrant, or was driving with a revoked, suspended, or canceled license, or the plate was on the wrong car, so it could have been a stolen car, or the car was reported stolen, okay? So obviously there are a lot of steps in the criminal justice system and a lot of hoops that we have to jump through as prosecutors before we arrive at a conviction, which presumably establishes you as a bad guy. But in no case were more than 0.8% of those images attached to bad guys, and arguably probably much less. So that's what we're arguing about here. It's not about whether or not we want to catch the bad guys or the good guys. We're not talking about the hit data, the people that go into the system for which you can decide are guilty or not guilty. We're talking about the 99.2% of people who are innocent. I got some good friends of mine in law enforcement, and they say, well, they don't say innocent, they just say not guilty yet, which I appreciate that. It's determination and vigor. But nonetheless, in our democracy, you are in fact innocent until proven guilty. So the 99.2% of these folks that we're talking about for these images, these non-hit data, are innocent people. Now, with that in mind, an article came out on August 17th in the Star-Tribune. Obviously, they put all this work of pulling 4.9 million images, and they probably stuck an intern to work on putting it in a spreadsheet and determining what you can find out about people. Well, there were 54 hits on Mayor Rybak's car, so they followed Mayor Rybak around the city and determined where he went, his daily patterns, and that, of course, became a big news story. Ha ha. But there was a vehicle repo service also that was able to get this data and track down a car that they were missing. Good for them on that, I guess. That's ingenious. I don't think that government's in the business of surveilling the public for the benefit of the private business. However, if you're the private business owners, kudos, I guess, to you for being ingenious on that. And a lot of people said, we got to do something about this. We have to do something because this is unseemly that we're tracking innocent people. And even on August 17th, Representative Cornish was quoted in that article saying, even though technology is great and it helps catch the bad guys, I don't want the good guys being kept in a database. Now, Representative Cornish has changed his mind on that. Some of you have changed your mind on that since then. Representative Gruenhagen's not here, but he told me he changed his mind on that too because he's been persuaded by law enforcement. Like I said, I'm very impressed with the lobbying power of law enforcement. Out there in the hallway, you got the Minnesota Coalition on Government Information, you got the ACLU, you got those other folks. They try hard. I got to give them credit. They show up and they make their pitch, but it's really against the mouse, against the elephant. I'm pretty sure a lot of you had got calls from your chiefs saying, keep all the data. And if I was a cop, I would say the same thing. I would say, give me more tools to do my job. Now, most of you know that I serve in the infantry, okay? And we have certain rules. They're called rules of engagement. And those rules are not set by infantrymen. Infantrymen do not get to say the rules that we have to follow in executing our mission. And I would submit to you that either should law enforcement. Law enforcement does great work. They are on the line. They arguably have one of the most dangerous, if not the most dangerous jobs in our democracy. But just like soldiers, we should not allow police to set the rules of engagement that they have to follow. It is you, folks holding election certificates, that decide what the rules are. And you get to consider not just what the police think, although that is critically important. We get some of our best information from the police. But we also have to consider constitutional parameters, privacy constraints, all other kinds of constraints that go well beyond what is the consideration of law enforcement. I pulled those other amendments because I thought some of them were nuanced and difficult to understand, so I thought the most important consideration was ensuring that we sent Representative Cornish into conference committee with a position that was negotiable against the Senate that did not compromise. 0 days, members. Now, there are 26 new members of the House, okay? But for those of you that were here 2 years ago, 0 days passed with 128 votes to 2. Okay? Representative Hillstrom offered 180 days at the time. 90 of you who were there, well, 90 people at that time 2 years ago voted against that. I'm asking you to stick with me on 0 days for my amendment. I did not originally intend, as I stated, to offer this because I thought Representative Cornish did a really good job, and Representative Scott did a really good job in negotiating this. This reserves the use of surveillance technology. Well, my preference is surveillance technology is reserved only for those suspected of crimes. I think that is the best policy, and that surveillance technology should not be used for those people who we don't suspect of crimes, unless we think, well, maybe they'll do something wrong in the future. We're running into that problem on the federal level right now with the Patriot Act, which a court just ruled was there was an illegal provision in the Patriot Act. They did not rule on the constitutionality of it, but they stated it was illegal. But it seemed like a good idea at the time, when to vote against it was to let the terrorists win. And many of us, after we passed it, kind of felt like, well, the terrorists did win, when we're constraining our personal liberties and having to completely change our lives and be surveilled by government in a way that never happened before on such a wide scale because of that fear. The first question you should ask yourselves on this 0 days is, number one, do you believe that people in the United States are innocent until proven guilty? I'm assuming the answer to that for all of you is probably going to be yes. So then you move on to second question. Do you believe in the United States you have a reasonable expectation of privacy in your daily schedule of activities? If your answer to this is yes, then any number of days more than 0 is an unacceptable invasion of your privacy. Now, on this question, the Supreme Court did not deliver a direct answer. There was a case called United States versus Jones in 2012. The decision came down by the Supreme Court in January of 2012, and it related to a guy in Maryland, in Baltimore, in fact, against whom the feds had secured a warrant. And the parameters of the warrant was that you could stick a GPS device on this guy's car, and you could follow it within the boundaries of a certain district and in a certain time over a number of days. Well, the police went beyond the geographical limitations of the warrant, and it went beyond the number of days permitted in the warrant in order to find information on the guy to secure a conviction. And the Supreme Court considered this. Now remember, they were not talking about mass global surveillance. They were talking about tracking the location of a single individual in that case. The Supreme Court said it was unconstitutional because they went beyond the parameters limited by that warrant. Note that in this case on LPR, law enforcement is asking you for this permission without a warrant, without any review by a judge. That is something, as the Supreme Court admitted in U.S. v. Jones, that we have not historically done. We don't generally do that in America, permit the police to track information on individual folks without a reason. You've got to have a reason. We call it reasonable suspicion. Now, a warrant is a much higher standard, which was required in this case. On this question, the Supreme Court stated, we accordingly held in United States v. Knotts that a person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movements from one place to another. That is true. And that is the standard in which they specifically considered this case. However, it added on, because it knew that technology is starting to get used for far more than tracking one bad guy from one place to another, which you needed a warrant on. They said, even assuming that the concurrence is correct to say that traditional surveillance of the defendant over a 4-week period would have required a large team of agents, multiple vehicles, and perhaps aerial assistance, our cases suggest that such visual observation is constitutionally permissible. It may be, though, that achieving the same result through electronic means without an accompanying trespass — they had to trespass to put it on the guy's car — is an unconstitutional invasion of privacy. But that the present case did not require us to answer that question. The Supreme Court punted, but it hinted in their language that, by the way, mass surveillance isn't the same thing as we have now. Eyeballs on, seeing someone drive one place to the other. Even the Supreme Court recognizes that. The D.C. Circuit Court of Appeals decision in Jones that went to the Supreme Court after it came through the D.C. Circuit Court of Appeals stated that a warrant was required in the Jones case because of its intrusiveness. And it said, a person who knows all of another's travels can deduce whether he is a weekly churchgoer, a heavy drinker, a regular at the gym, an unfaithful husband, an outpatient receiving mental health treatment, an associate of particular individuals or particular groups. You could determine all of that even over the course of a person's driving habits over the course of 30 days. It is unseemly that we would continue this. The procedural jurisprudence over the course from 1967 until U.S. v. Jones in 2012, from federal courts, from Katz v. U.S. through to U.S. Jones, establishes that the U.S. Supreme Court will probably rule collection of surveillance data on innocent people to be unconstitutional when done in this massive manner. You're going to be voting on this today. You're going to be voting on this in the same way our federal representatives voted on the Patriot Act over 10 years ago. And it seemed like a good idea at the time, right? Because we didn't want the terrorists to win, just like we don't want criminals to go free. And there's all kinds of stories, and I mean good reasons. Kidnapped kids. Look at my daughter's 14 years old. Well, I want the police to have every tool available to protect my daughter. If something happened to her, you're darn right I do. I also don't want to be explaining to my daughter 20 years from now that I voted for a bill that changed things for her and her liberties, and she's growing up now a different way than I did. I'm worried about that too. This is a balancing test you have to consider. In this balancing test, I submit law enforcement is absolutely doing their jobs, at least insofar as their desires. The lobbying efforts, as I stated, I think are a bit unseemly, crafting a compromise on the House side and then going over to the Senate and sending back essentially their static position. And you've heard, I'm sure, from your chiefs, your sheriffs, that they want this tool. I get that. Like I said, I would want it too if I was in their shoes. But you are here to represent your constituents as well. Please consider that. And if you want the compromise reached by Representative Cornish and Representative Scott, I ask you to stick with me on 30 days, at least in the hopes that we can give honor to the work that was done. Sorry, did I say 30? 0. Thank you. Tony caught me on that. See, he's got my back. Yeah, I changed my mind too. Please send this over to the Senate with 0 days so that we can come back at least with some semblance of an agreement that was arrived at in good faith by Representative Cornish and Representative Scott. Please vote yes on this amendment.
Member from Washington, Representative Schoen.
Thank you, Mr. Speaker. I should be able to do this a little quicker. You know, the reality is, you know, we're talking about the access to data, and this was an agreement that was put together by Representative Cornish and all the parties interested. And, you know, when it benefits us, then we compare ourselves to the Senate. When we don't want it, then we don't say we're the Senate. Hey, we're the House. This is our bill. This is what we did, so let's stick with it. But what we need to talk about is access to that data. And if we don't do something, then your data is going to be available to every single person, whether it's some credit card company or a tow company, a repo company, whatever it may be, then they can come in and track you and market to you whatever you want. And I think that's wrong too. That's the issue we're trying to fix. And when you say that we all supported 0 days, well, that was the bill we had the chance to vote on to protect people's identity and their data. That was all we had. That was the only chance, because I can guarantee I supported Representative Hillstrom's bill, and I said this in committee more than once that, you know what, I wasn't happy with 30. I certainly wasn't happy with 0, but that was the compromise that we put together, because we don't all get what we want when we're in here sometimes. You know, we've heard this argument time and time again come through committee. This is the bill that the House put together in the committees through the committee process over this period of time. It should go in the shape that Representative Cornish has set it up so that we can get over there. You know, the subject of the data can go in and request a check on that anytime, and they can get access to it. You know, we could go into all the stories. We've had this argument about protecting children, protecting public safety, but the reality is we do have to protect the data of Minnesotans and their privacy, and we also have to protect their public safety interests as well, and that's what they expect. We have these tools available to us. Using them appropriately, properly, and controlling the access to that data is the key, and many departments are taking those steps because we've seen what has happened with DVS. DVS has taken great measures. It's controlled access. You have to provide more information than you ever did before. We're taking those steps appropriately now. Let's continue to work with it. Please support Representative Cornish and vote down the Lesh amendment, and I don't know that I would, unseemly might have been a little harsh, Representative Lesh, but I know you're passionate too.
Member from St. Louis, Representative Simonson.
Thank you, Mr. Speaker and members. And Representative Lesh, it's very rarely that I'll disagree with a position that you take, but today I'm going to, and I'm going to speak against your amendment. And I want to give credit where credit is due, and Representative Cornish and folks on your side of the aisle, and just as many folks on this side of the aisle too, that have come together and worked out a compromise agreement. I certainly would have been in support of a longer period of time, but I understand negotiations and I understand compromise. And in this case, members, there's a lot of different arguments that an individual can make, and I know everybody's got their own beliefs. And at the end of the day, you're here to represent your constituents. But one of the things that I heard today was, how do you best protect the interests of individuals? I'm not here representing law enforcement, right? I mean, I'm not here at the behest of the MPPOA or the Chiefs Association or the sheriffs. I'm here to represent my constituents. And I think that by giving law enforcement a tool that will help them solve crimes going into the future, that makes sense to me. And I think it makes good sense to my constituents. And I think that ultimately they trust law enforcement. Now, I'm a pretty big believer in protecting data from those that shouldn't have access to it. Somehow I ended up on the Data Practices Commission, so I get the opportunity sometimes to hear a lot about that. And I believe in that, but I think there are also cases where we can give access to information to certain people that we trust. And that's what this really boils down to for me, is that by providing access to information, and you heard Representative Cornish walk through the steps that's in the underlying bill now, it's pretty protected, even from law enforcement. I don't think that anybody here could have put together a better compromise bill than what is there. So for me, it just comes down to protecting the interests of the individuals in my district, and I think it makes sense, and I would ask for a no vote on the Lesh amendment.
Member from St. Louis, Representative Metza.
Thank you, Mr. Speaker. Members, I'll keep it brief here. I support the Lesh amendment. I've got an amendment A1 that does something very similar, and think that for many of the reasons that Representative Lesh articulated pretty well, that he's earned my support today. Thank you.
Member from Ramsey, Representative Pinto.
Thank you, Mr. Speaker. I speak against the Lesh amendment. I'm in the unusual position of being very happy with the compromise just on substantive grounds. I would not favor, I have great concerns, I guess, with the longer period of 90 days, 180 days for many of the reasons that Representative Lesh gave. But I have to say, members, in my experience, 0 day, if we're going to bother allowing law enforcement to use these license plate readers at all, 0 days just does not make any sense to my mind, is not practical. Because as the license plate is read, the realities are that it may take some time for the car to be reported stolen, for the officer to be reported down, for the incident to be reported to have happened. Now, as the days go by, that concern about responding to an immediate incident goes away, right? Maybe at 3 months or 6 months, 90 days, 180 days. At that point, you really are using this data to prove up some past crime. But if it's your situation happening in those first couple days, first couple hours, why would we say that in the first minute, if it happens that there's not already the crime having been reported to get the license plate data in there, we're just going to discard that information? So members, to my mind, 30 days, and we could go to, could have been 14 days, could be 45 days, but something in that range, to my mind, responds to current incidents without setting up a database that could be mined for past incidents and proving up past crimes. So members, if we're going to allow law enforcement to use this technology at all, which my understanding is that we are, that's not under debate at this point, then it does not make sense to me to say that we're going to restrict ourselves to, in the first couple seconds, that then that data disappears, and if your car is reported stolen half an hour later on, or actually forget about the report, it takes a while for information to be entered into the system. And in that case, that 30 minutes has gone by, sorry, out of luck. There's got to be some reasonable period of time, and is 30 days in the range of reasonableness? To my mind, it is. I would urge a vote against the Lesh amendment.
Member from Blue Earth, Representative Considine.
Thank you, Mr. Speaker. I just looked up the quote that I was looking for. Those who sacrifice liberty for security deserve neither. Benjamin Franklin. I think I will support Mr. Lesh. Thank you.
There being no further discussion, the member from Blue Earth, Representative Cornish.
Mr. Speaker, I'll make it real quick. I would ask you that you don't support the Lesh Amendment. Nobody really cares if you go from Ace Hardware to Cubs or the sandwich shop unless you smack down the owner and commit a crime. I mean, you're in for a short amount of time in this database, and the innocent people are still innocent. And just trust your members on your committee on civil law and public safety. Your members in both parties overwhelmingly approved. It's kind of like me in transportation. I don't know really a lot about it, the basics. I depend on my colleagues on the committee to inform me before it gets to the floor. And in this case, your colleagues have given this overwhelming approval on a bipartisan basis. So I just would ask you not eviscerate the bill and leave it at 30 days. Thank you.
Member from Wright, Representative Lucero.
Thank you, Mr. Speaker. I just asked for a roll call.
A roll call has been requested. Are there 15 hands? I do not see 15 hands. There will not be a roll call. Any further discussion on the amendment? All those in favor, please signify by saying aye. Aye. Opposed, say nay. No. The motion does not prevail. The amendment is not adopted. There's another amendment at the desk. The clerk will report the amendment. I wanted to, though.
Metsa moved to amend Senate File Number 86 as amended, and the amendment is coded A1.
Call upon the author of the amendment from St. Louis, Representative Metsa.
Thank you, Mr. Speaker. Well, I think we got our answer on that last roll call, so I'll withdraw this one.
Representative Metsa withdraws the A1 amendment. There's an amendment at the desk. The clerk will report the amendment.
Lucero moves to amend Senate File Number 86 as amended, and the amendment is coded A4.
I call upon the author from Wright, Representative Lucero.
Thank you, Mr. Speaker. A few weeks back, I met with representatives of the Department of Public Safety and the Bureau of Criminal Apprehension, and the purpose for the meeting was to, or for me, to gain a better understanding of the technical architecture of automatic license plate readers and the data flow, etc. And it was a great conversation in helping me understand that. In that conversation, we also spoke about security policies. And I did pass out a handout, members, and there's a few pages on it. The very first page is the first page of this document right here. This is the security policy that is written by the FBI, and it is required of all agencies or municipalities that choose to use automatic license plate readers. The second page in the handout is the first page of this document right here. This is the security policy for the Bureau of Criminal Apprehension. And the way this operates is security policies are common in the industry that I'm in. Organizations have them. You've probably run into them yourselves in your places of employment. And the bottom one, being the FBI, serves as the foundation for the minimum standards of configurations, etc., in an IT infrastructure. The BCA then sits on top of that, and a third would be a local municipality would sit on top of that. Then the stack in its totality becomes the sum total of the configuration standards and policies and procedures that must be adhered to in an IT infrastructure. In the field I'm in, we're well versed with regulatory compliance mandates such as payment card industry. Well, that one is not by the government, but it's industry driven. But it's payment card industry, and it serves the same purpose, having minimum standards for the protection of data. Sarbanes-Oxley, some of you probably, or most of you probably heard of that. And that is, again, it sets out standards that are required to be adhered to for information technology infrastructures. And then HIPAA and high tech. Each of these mandates is applied to a different industry depending on what industry the business is in. But the point is, it's well known, and security standards are common practice. And in that industry, IT audit has risen up. And the function of IT audit is to simply validate that companies or industry is adhering to the mandates that are required. So what this amendment does, with that foundation, what my amendment seeks to do is simply take that same concept that's well understood,
Mr. Speaker?
It's very mature in other
Mr.
sectors.
Speaker,
Member from Washington, Representative Schoen, for what purpose do you rise?
rise to a rule of order.
State your, I believe you mean a point of order. State your point of order,
That's
Representative Schoen.
Under 4.03, I think Representative Lucero's amendment would change the budget behind the bill, and therefore should be ruled out of order.
Mr. Speaker,
Hold on.
it was my intent to withdraw.
Hold. Representative Schoen, do you want to withdraw your point of order?
Noting what he just said, absolutely.
Yeah. Member from Wright, Representative Lucero, if you want, you have the floor. So.
Thank you, Mr. Speaker, and thank you, Representative Schoen. And what I want to do is just draw attention to this very important concept that private industry and others are adhering to, of taking information security policies and then using IT audit to simply validate that they are indeed adhering to them. And so what my amendment would have done was to take these security standards that must be adhered to and simply validate that indeed they are being adhered to. So I have the pleasure of being appointed to the Legislative Commission on Data Practices and Personal Data Privacy with Representative Simonson, Representative Scott, and others. And I hope that this topic is one that we can discuss in the interim coming up here, because it is very important to ensure, again, the compliance to best practices and other security policies. So with that, Mr. Speaker, I withdraw my amendment.
Representative Lucero withdraws the A4 amendment. There being no further amendments at the desk, the clerk will give a bill its third reading.
Third reading, Senate File Number 86, as amended.
Third reading. Discussion to the bill. Seeing none, the clerk will take the roll. Hold on, I'm sorry. Members from Anoka, Representative Scott.
Thank you, Mr. Speaker. You're in a big hurry up there. Members, Representative Cornish and I and several of the stakeholders did work hard on this bill. I am a zero person. I am for zero time for constitutional reasons. I believe that this is probably the best that we can get right now. And I know that doesn't sound like a stunning endorsement, but there are some really, really good protections in here for private citizens and the handling of the data. As we go forward at conference committee, I mean, we have some really good footing. I would have liked to have seen us get a lower number of days moving on to conference committee, but I think we'll be able to defend the 30 days. And a couple of the things that give me some satisfaction in this bill is that there will be an annual audit, so that we don't wind up in a situation like we had with the DNR employees looking up driver's license data of private citizens, and so that will be tracked, and so those types of abuses will not be able to occur. So with that, folks, I would just encourage a green vote on this bill. I believe it is a good compromise and gives us a strong position going into conference committee. Thank you.
Member from Ramsey, Representative Lesh.
Thank you, Mr. Speaker. And members, I had to fight for 0 days and still will, but I would repeat that I appreciate Representative Cornish's effort to compromise. I wasn't behind closed doors on those negotiations of how Representative Cornish did it in handling and suggesting the DE1 amendment in civil law on March 13th. But what the DE1 amendment did when they offered it, and there were 2 subsequent amendments after that, but in my opinion, the strongest protections were contained in that DE1 amendment, which is in the current bill that's going to be sent out to conference. Unless the Senate does the courageous thing and decides to accept the language, the compromise language that we arrived in at the House. So I really would encourage the Senate to be courageous in their vote and ensure that, and just take the House language. But the DE1 amendment, what it does is it states, and this was with Representative Cornish and law enforcement came up with this, is it states that police must have reasonable suspicion, independent, established, articulable reasonable suspicion in order to go after people that have non-hit data. And I think that's really important because essentially what that does is it allows law enforcement to self-regulate. If law enforcement is going to set a squad with a license plate reader outside a gun show or outside an environmental rally or outside some other rally that is protected by free speech rights under the Constitution, or outside the SOB parking ramp to track when you come and go, if they're going to do that, they have to have reasonable suspicion to make that happen. And if for some reason they do that in another rally, and they catch someone with something else, and they don't have independent reasonable suspicion, then all the evidence they collect that maybe they couldn't have otherwise collected is out. Based on Fourth Amendment principles, it becomes fruit of the poisonous tree, and evidence, even if they find you with a pound of marijuana, you are not prosecuted. It is my hope that the risk of being irresponsible with this data, the fact that risk would result in guilty people going free, will be enough for law enforcement to tread extremely carefully with this very powerful tool that stands the chance of implicating our civil liberties. So I wish Representative Cornish the best of luck going into conference with this, and I urge people a green vote.
Is there any further discussion? Seeing none, the clerk will take the roll.
The clerk will close the roll. There being 126 ayes and 3 nays, the bill is passed as amended and its title agreed to.